meeting. And in attendance are Commissioners Brooks, Matari, and Duncan. Are there changes to the agenda?
Commissioners, I'd request that you flip-flop D and E
Okay.
so that E could go first.
All right. Are there any objections to that?
No objections.
Okay, so that's fine. Opening remarks is I actually have to leave about 10:30 because I have another meeting that I can't miss at 11 o'clock, and that's normally not what happens. We don't normally book so close together, but that's what today is. Conflicts of interest? Are there
None.
any? None? All right. And item E, public hearing. So this is APP 20, which is an appeal, 22-0003, and it's appeal of a minor subdivision 21-0043, and I will turn it over to staff.
David, we don't have any of the network drives up, so we can't access it right now. As soon as Glenn gets the.
Commissioners, apparently the network's down. I can set the stage while perhaps the staff can load it on a thumb drive and bring it back so that we're not having to go through the network.
Okay.
But the essence of this case is that I approved a minor subdivision because I thought it met code. We do those kinds of things based on advice from our legal counsel, in this case, understanding that we believe that the existing covenants allowed us to go forward. And that's our position. People on the other side take it differently, and that's what you're going to hear today. So this really is, frankly, more of a legal issue than a planning one. And that's about as much of a stage as I can set. So if you don't mind waiting just a minute, we'll see if we can find a thumb drive of the data that we wanted
For
to
the
present to you.
presentation.
Thank you.
Okay. And then Civil Deputy Prosecuting Attorney Pat Braden is here as our counsel. And so I would ask Pat to remind me or remind the board of the appeal process. So we're going to hear from staff.
Yeah, staff will do a very brief presentation, just setting out the material facts relevant to this appeal. Then the appellant and/or legal counsel will have the first crack at oral argument.
Okay.
Then anybody that is aligned with the appellant's position will have 3 minutes each.
Okay.
Then the respondent and the county will have their opportunities to respond. And then anybody in line with those positions would go after that. And then finally, the appellant would have the opportunity for rebuttal.
Okay.
And then it would be,
Deliberations.
yes,
Okay.
which can occur now, at this time, or can be scheduled for a later date, particularly.
Okay. And the later date is June 15th is our next meeting. I've got my calendar here.
I think so. I'm just wanting to have consideration for your time constraints.
Yes, I
The only
do
reason I
appreciate
suggested
that. Okay.
Vlad, how much longer do you think?
Okay, I see what happened because we're going to be out of town. So the 15th is the next one. So if you want to deliberate later, it'd be June 15th. Okay. Of all the days for technical difficulties.
It's called Murphy's Law.
Thank goodness for thumb drives and storage. I'm not dealing with Bernoulli disk anymore.
There's a term I haven't heard in a while.
And 25 years.
Remember thinking those were the greatest things since sliced bread.
Mm-hmm.
Okay.
At this time, I'll ask Amy to open up for the staff.
Okay.
Okay, thank you for your patience. Amy Hillen, planner for Kootenai County.
Is your microphone on?
Yes.
Okay, thank you.
Yep, I'll put it closer to you. Planner for Kootenai County, again, this is Amy Hilland. The appeal request is an appeal of a decision made by our director, an administrative decision to approve the Valley of Life subdivision, MAN 21-0043. The applicant and owner in this case is Lubov Kolchutsky, and the appellant is Mark Saul. And this is a slide I generally bring to these appeals. This is a general rule or general steps to observe during an appeal hearing. So I will do a very brief introduction, and then the appellant will present their case in chief and any testimony in support of the appellant, and then the county will present their case in chief and any testimony in support of the county, and the appellant will have a chance for a rebuttal. The minor subdivision is located north of the city of Post Falls and west of the city of Rathdrum. It's located approximately 900 feet north of the intersection between West Hayden Avenue and North Spokane Street. The site is developed with a single-family residence and accessory buildings. It is located in the rural zone where the minimum lot size is 5 acres. And the subdivision was a 2-lot minor subdivision. Each lot was 5 acres in size. They each would have individual driveways off North Spokane Street, which in this area is a private road. The water would be provided by East Green Acres Irrigation District, and each lot would have its own septic and drain field. On July 13th, the Community Development Director signed and approved the minor subdivision. On August 9th, Community Development received a notice of appeal from Mark Saul on the basis that the parcel is subject to CC&Rs that restrict further subdivision. November 3rd, this matter came before the hearing examiner, and November 18th, the hearing examiner submitted a recommendation to approve the appeal and request a reversal to the decision made by the director. Leading up to this public hearing, there were 7 comments submitted, 3 in support of the appellant, 2 opposed to the appellant, and we did receive 2 that were marked in opposition but were indicated that they were against subdivision. And I stand for any questions you have. This is a picture of the actual full subdivision plat.
Okay, questions?
No.
Okay. All right, so we're ready for the appellant. And you, if you're comfortable, you can just sit there and turn your microphone on.
I'll
But
be using some exhibits. if
okay,
that's So
yep,
I'll go ahead and
absolutely.
do that.
Perfect.
I have them up, but I'm just not displaying.
Okay. Anybody on Zoom, please mute yourself until it's your turn to speak.
So I do have them open, but they're just not displaying.
Techie Ben to the rescue.
You're all in trouble now.
Well, I can start while they're pulling that together, if that's okay. So I want to start by thanking the commissioners for giving the opportunity to speak today and hearing this matter. So ostensibly.
And I'm sorry, sir, who are you?
Oh, sorry. My name is Casey Clifton on behalf of the appellant, Mr. Mark Saul. I apologize. So ostensibly, we're here over a disagreement over the term lot, right? So, but I want to kind of discuss the burden of proof here to begin. So, Kootenai County Code 8.8.505 puts the burden of proof on the appellant to establish by a preponderance of the evidence that the department's decision approving this minor subdivision was erroneous. So what is the preponderance of the evidence? I think the hearing examiner really succinctly stated that it is more likely than not. Simply a greater than 50% chance the decision was wrong. So if we have a 51-49, that's all it takes. So we believe, so I guess the overarching question here is, does Mark Saul the appellant prove that more likely than not, approval of the minor subdivision is erroneous. And we believe that Mr. Saul has satisfied that burden, and the hearing examiner in no uncertain terms agrees. So for clarity purposes, the appellant's position is that the subject property was made subject to the CC&Rs at issue, and that these CC&Rs include a prohibition on the further subdivision of any lot. And as a result, any approval of the subdivision of that lot would be improper. In fact, this was the county's initial conclusion. So pardon my clicking here. I don't have, am I able to move this? I need to be able to see the scroll bar, otherwise we're going to be here a while. So if we go down here, I'm just going to try not to make anyone seasick. To Exhibit N, and this was attached to the declaration of Mark Saul. And we have an email. And this email is dated November 29th. It's from Amy Hilland to Connie Kruger, who assisted in the preparation of this short plat. And it includes statements attributed to Mr. Braden that the county attorney has concluded that the CC&Rs do apply to the subject property and therefore the subdivision restriction is also applied. It further says that if they want to continue forward as proposed, they would need to remove the property from the CC&Rs. And it also discusses the county's own policy that they don't approve subdivisions in direct conflict with CC&Rs. And that it would lead to a civil dispute, essentially trying to avoid downstream issues in litigation. So, and it cites finally to another case, APP 21-0003, in which that very decision was made as a result of an application of CC&Rs to a subdivision. So, in reality, the county and Mr. Saul actually agree on several points, and it's shown in the staff report that's dated November 2nd, 2022. We agree that the appellant has sufficient standing to appeal this decision. We agree that the CC&Rs at question were properly recorded against the property, and we agree that the CC&Rs unambiguously prohibit further subdivision of lots, but we disagree on the scope of that last word, lots, and whether it's ambiguous. So on that staff report, we get the justification for the basis of that decision. And what it says is that ambiguity exists and lies in how the CC&Rs define the term lot, right? And so they apply the rule that they pull out from a case here called Pine Haven. And it says here that ambiguous provisions of restrictive covenants are to be construed in favor of the free use of property, and that restrictions that are not clearly expressed are not to be extended. So applying this rule of construction, the staff concluded that restrictions on further subdivisions contained in the CC&Rs only apply to those parcels in which it was originally attached to, which is this Finneman Farms. You're going to hear that name a lot. And so their position is basically it's ambiguous, can only refer to Finneman lots because ambiguously provisions should be construed to the free use of land. So I want to look at the definition of lot. Right, that's where we should start. So I'm going to jump up to Exhibit F. Again, apologize. So here's Exhibit F. And this is the CC&Rs at question, right? And this is the original recording of the CC&Rs. And if you're taking notes at all, I would just note that the recording number, right in the margin, 118-194, it's going to be a very reoccurring theme in the presentation. But here we have the declaration to Finneman Farms, recorded by Ethel Finneman Carlson back in April of 1990. And the disputed definition here is section D here on page 2. And it states that lot shall mean or refer to any particular and separately designed parcel of land resulting from the subdivision of property in accordance with the plat of Finneman Farms filed for record in Kootenai County. Now, to talk about Pine Haven a little bit more, Pine Haven is a case regarding CC&R interpretation, as it relates to the short-term rental use in a planned subdivision. So we're talking about Airbnbs, okay? Really, the facts of that case don't matter here, but there's more than the one rule that the county relies on that was placed into that case. And we should look at all of the rules. So first, it says that if ambiguity exists, it will only exist and be found when a covenant or document is capable of more than one reasonable interpretation. And I highlight the word reasonable. And to determine whether or not a covenant is ambiguous, the court must view the whole agreement. So we cannot pull a single provision out and apply it across the board without reading and reviewing the entire document. So when there's no ambiguity, then the plain meaning of the document exists. And I think it's important to keep in mind through all of this that Kootenai County Code 8.4.1107 requires the primary goal in any deed interpretation, which is what this ostensibly is, to give effect to the real intention of the parties that filed it. So we got to look at the intentions of Ethel Carlson and what she was trying to do with this document. So if we look at these rules, right, it's our position that definition of lot is not ambiguous and that the county failed to view the entire agreement in its totality. So I just want to take a brief moment and look at how the word lot is used in the agreement. So, and I want to use it from the county's view, right, that lot, it can only mean lots in Finneman Farms, and go through and talk about how this works. So if we start here, this authorized uses, this is really the subject provision that's at play here. It talks about the lots in Finneman Farms, right? So if lots is defined as Finneman Farms, we're saying the Finneman Farm lots in Finneman Farms, we're saying the same thing twice, right? So right from the get-go, the definition isn't used in the way it was defined initially. And then, of course, there shall be no further subdivision in the lot, and that's the provision, the specific provision at issue today. But lot is mentioned several other times in the agreement. For example, we look at page 5, and we look at section C here at the top. No inoperative vehicle of any kind or nature will be permitted to remain on a lot. Well, that means that it only applies to Finneman Farm lots if we take the county's position. If we take the county's position that a lot can be used, and all these lots, one of these lots can be used for dumping grounds, right? If it only applies to Finneman Farms. A lot can be used for legal or offensive behavior. Of course, there's zoning codes that are going to prevent some of this use, but let's look at it on its face. It continues, if we go to the following page and talk about the miscellaneous uses, all utility services on lot shall be underground. Well, if we take the position that only applies to Finneman Farms, then that provision doesn't apply to outside lots. Same with provision B when it talks about fences. Well, we have a restriction on the type of fence that can be used, but if we take the position of the county, that doesn't apply to the subject parcel. And remember, the county agrees that this has been attached to the subject parcel. Then again, we look at provision C, again, lots shall be appropriately landscaped. Well, that requirement is not necessary under the county's provision. So essentially, we're taking the position and rendering all of these restrictions meaningless if we take the county's position that it only can refer to lots in Finneman Farm. I think it removes the entire purpose of subjecting the property to the covenants in the first place. So what I think really the analysis really should sit in is this annexation requirement. And this is how the subject property was actually placed under the rule of the CC&Rs. So it provides clarity, and it's not part really of the county's review in the staff report. So the first paragraph here talks about Ethel Carlson, how she owns additional properties adjacent to Finneman Farms, right? They're also located in the southeast quarter of section 15, which is where we're at. And then it goes in the second paragraph that the additional lots from the above described property owned by Ethel Carlson. Well, that term lot cannot refer to Finneman Farms. It refers to the parcels adjacent to Finneman Farms. Again, if we take the county's position, this can't apply. It essentially, it renders the annexation process moot. If that was the intent of Ethel Carlson, it wouldn't have ever been included. The process wouldn't be allowed. So really, I think it's not that the term, well, see, excuse me, I've lost my spot here. So I think the county's narrow interpretation of lot is inconsistent with the actual usage of the word in the CCRs when you view the agreement as a whole. So instead, the more reasonable interpretation is that this section provides a mechanism for additional lots to become subject to the CC&Rs to the same extent as lots in Finneman Farms, and therefore modifying and expanding the definition of lots. So accordingly, the county's position that there's no provision that brings the annexed lots within this definition, I think is incorrect. This very section describes the process in which you would effectively subject annexed parcels to the same definition of lot as would be applied to the parcels of Finneman Farms. It also talks about making these subject to these declarations here. Not a portion of the declarations, not particular provisions, it references the entire declaration. So, it's our position that when you take a reasonable interpretation of the document as a whole, taking Ethel Carlson's intent into mind, the subject property, or there is no ambiguity when the document's construed that way. But let's take the county's position that ambiguity exists. So what does that mean? What does that review look like? If we're talking about a legal analysis here that the county performed. So I want to return back to Pine Haven, right? We already talked about a couple rules. I want to add two more. If there's ambiguity in covenants, the court must determine, again, the intent of the parties at the time the instrument was drafted. And to determine that intent, they can look at the language of the covenants, the circumstances around their formation, and the conduct of the parties. Ethel Carlson's conduct as a result of these. So let's look at that. She's the party, the original party to the CC&Rs. And again, I'm going to keep hitting this. Recall, the county agrees that the subject property was made subject to these CC&Rs. So I have two surveys. And we saw earlier an overhead shot of the subject. I'm happy to turn this so that we can see it. So this is the area that we were just showed earlier, right? And this was a 92 survey performed by Ms. Carlson, and this is the south half of section 15, and you'll note that here is the subject parcel that we're talking about, parcel B. We also have, here's Finneman Farms, are the 7 lots across the bottom to the south, directly on Hayden Avenue. And then we also have several other parcels, a portion of this. And I'm going to talk about each one of these, and we're going to hear names about previous owners, Dodge and Goodall and Peterson. But this just kind of lays the land of what area was owned by Carlson and her intent. There's a second survey, and this survey, I apologize for the darkness of the survey, this is how it's recorded. This is directly to the north of what we just saw, and these are 8 more parcels that Carlson had surveyed in 93. And I just want to note for reference how they're numbered 1 through 8. My client owns parcel 3 for reference. So I want to look at the parcel history, and I want to look directly at the subject parcel. And bear with me, I'm going to have to go around the horn to get this back the right way. So I'm going to jump down to Exhibit H. Try to do it as quickly as I can. Oops. All right, so here's Exhibit H. And this is, I call this the Goodall deed. This is actually the subject property. And this is the conveyance that the county has agreed. I know it's a little difficult to read on here, but here we have John Finneman and Ethel Carlson conveying the property to the Goodalls, Faye Allen and Teresa. This is a recorded document in 93. And you'll note that it says subject to the attached covenants. Right? And I asked, earlier I mentioned to recall the 118-1914 number. You'll see that it's attached. Right? The county agrees that's occurred. Well, this is not the only property in the area that she did this to. So if I go back to Exhibit G, the one just previous to this one.
Mr. Clifton, can I just interrupt for a second?
Yes.
Mr. Braden, he's at 15 minutes. Is this a 20 or 30 minute?
I was provided 30 minutes at the previous.
30 minutes.
It will be shorter than that,
Yeah,
but I
Okay.
was provided 30 minutes.
yeah, I think that's reasonable.
I've hit my heart out, and so I'm going to need to go. So my other question is, if I watch this later, am I going to be able to vote on this?
Yes,
Okay.
you would want to indicate as much once you go into deliberations, but yeah, that is perfectly fine.
Before we go, then, we need to get this on Zoom, so the rest of this is,
Yep.
so that you'll be able to see
you going
this on
upstairs?
Zoom.
Yeah,
Ask Julie
and
to
I'll
bring
want
my
to
briefcase
refer to
down.
that during my
I need a,
presentation also, these exhibits.
All right, I'm sorry, folks, but this is a once-a-year meeting that I gotta go to, and that's how it rolls, so.
David, can you see this on Zoom? Can you see the PDF on Zoom? I am sharing. Let me try to share.
Dragging the Zoom, the whole Zoom.
Oh, there it is.
You got it?
You're in.
All right, you can have the mouse back.
Thank you.
Sure.
All right. So, like I said, we're talking about other properties in the area. I've lost there it is. In the area that are subject to the same CCNRs. So here, this is what I call the Dodge deed. Okay, and this is for the property that's directly to the south. This was parcel A in that first survey we looked at. And again, we have a conveyance from Ethel Carlson to the Dodges, and it makes it specifically subject to the attached covenants in the same manner that the previous deed was. So again, we scroll down, and 118, 1914, same covenants. And yet there's more. We jump down to Exhibit I. And here we have another conveyance, and this is the part of what I call the Peterson deed. This is parcel C. It's directly across the street from the subject parcel. So here we have a conveyance from Ethel Finneman to John Finneman, or Ethel Carlson, excuse me, to John Finneman. And so this particular deed did not have the CCNRs attached, but the predecessor, John Finneman, he subsequently conveyed it to the Petersons. And the Petersons, Catherine Peterson and Paul Peterson, subject to the attached covenants. They even initialed the location, showing their acquiescence to that attachment. And again, we have 118, 1914. So now we have 3 additional parcels. And then finally, we have an Exhibit K. And this is the largest encumbrance that we'll talk about. And Exhibit K, I call this the CCNR extension. It's not conveyance deeds, it's an encumbrance. We have a series of parties that have agreed to be encumbered by this at the behest of Ms. Carlson. So here we have 118, 1914. This is the original document that we keep hitting. And if you scroll down, I'll see the original signatures of those individuals of Finneman Farms. Further, you'll see the Dodge deed we discussed earlier, and then a series of parcel numbers attesting to the attachment of this. So here we have, and this is why I referred to those previous surveys, we have parcel 1, we have parcel 2, 3, nothing was attached to 4, parcel 5, parcel 6, 7, and 8. So now we have 10 additional properties besides Finneman Farms. And so that's a total of 17 properties that are now subjected to the CCNRs. Right? So this is not a one-off situation with Ms. Carlson just chose to attach to one property. Her conduct demonstrates that she was attaching it to all these properties to enforce a uniform scheme over all of the properties. And if we continue to Exhibit L, this is the title policy that was submitted by the applicant as part of the process. And it notes here that that Goodall deed, 1295036, with those restrictions, was attached. So that also demonstrates that the property was purchased with notice that the CCNRs were there and that there was an inability to segregate. So Carlson's actions demonstrate her continuous and clear effort to subject the properties. to the CCNRs. So under the county's interpretation, these efforts would be meaningless, right? And that can't be her intent. So if you look at the evidence outside the corner of the CCNRs, it clearly demonstrates the original parties to that, all the restrictions, their intent to subject all of the properties to those restrictions. Now, I want to briefly touch on the previous board's decision in APP 21-003. All right, this is Exhibit Q. I'm not going to scroll to the exhibit, but on page 8 of that, the hearing examiner provides a very succinct argument. First, I should start with the contention that we, either the Kootenai County Community Development Department or the Kootenai County Board of County Commissioners, do not have the power or legal authority to remove restrictions, covenants, or other covenants from private real property in this manner. Appellants are essentially asking us to either ignore the CCNRs or determine they should not have any legal effect. Now, in that particular case, they were trying to do a subdivision and result in parcels less than the allowed acreage size for that area. The court, or the board, unanimously approved the hearing examiner's decision. So here's the hearing examiner's decision in this matter, right? He agreed that it should be reversed and denied, and he disagreed with the county's legal conclusions and belief that the staff's original assessment was correct, and just says, as with the appeal we just talked about, coming to this legal conclusion, deciding the applicability of legally attached CCNRs is putting the cart before the horse. The Community Development Department, including appellate hearings in front of the hearing examiner, is an improper venue to decide property rights. As I stated in APP 21-003, if an applicant wishes to remove an encumbrance, the proper venue to do so is the Kootenai County District Court, and our inquiry should stop there. So we asked the board to apply the same standards to that previous appeal to this appeal. Again, the county's already conceded the CCNRs encumber the property. We have a title report confirming the same. And just as in that previous one, the county should not ignore the CCNRs or make a determination they have no legal effect. So we finish back where we started. Does Mark Saul, the appellant, prove that more likely than not, the approval of the minor subdivision is erroneous? I think the answer is a resounding yes. As such, the board should adopt the hearing examiner's findings and approve the appeal, and thus deny the application for minor subdivision. Now, alternatively, because we've had this second hearing, the Kootenai County Code 8.8.507 does allow this board, having now had the hearing, to remand to the director of the hearing examiner for further proceedings. And if they choose not to summarily accept the hearing examiner's decision, we would ask that the board choose to subject their remand to a determination of the applicability of these CCNRs, either by requiring the applicant to seek a court order demonstrating they don't apply to the restrictions, or to hold a vote via the variance method that's included in those CCNRs. And with that, I conclude my arguments. If you have any questions, I'm happy to address those.
Thank you very much. No. Thank you. So next up are,
Any person signed up to testify in support of the account?
okay, do we have that, information? Does anyone, had they signed up to, in support of the appellate who want to testify? Anybody online?
Is there anyone on Zoom that would like to support the testimony at this time? Apparently not.
Okay. So next up would be the applicant.
Scott, you want to go first? You want me to go first?
I'll let you go first.
Okay. And if you could put that other presentation up. And then go to page 20.
And you're representing the county?
Yes.
Okay.
And go to page 20. Is there any way?
And share it on Zoom. It's not yet. There we go.
Okay. Why is this not working? Okay. Well, it was working. Okay. In appellant's case in chief, the argument was raised that we're arguing about one word, lot. Why are we arguing about one word, you might ask? And my answer would be words mean things. You saw the definition of lot earlier. It's actually, I'll put it up again. Whoops. And you can read it there, but I would point out, it says lot shall mean or refer to any particular and separately designed parcel of land. Actually, I think that means designated, but it says design, resulting from the subdivision of property in accordance with the plat of Finneman Farms filed for record in Kootenai County, Idaho, at Book F of Plats, page 209. That's important. That's a limiting definition. Whatever lots, the lots that were created through the recordation of the plat at Book F, page 209, are the ones that are within the definition of lot and sold or held for sale to members of the general public, other than any property owned for that's dedicated to the public for use as free right-of-way. But the appellant argues that there's this annexation clause that uses the term lot in a manner inconsistent with the definition of lot elsewhere in the CCRs. I think that by itself is the very definition of ambiguity. Something that's subject to two or more reasonable meanings. Does lot mean what it says in the definition, or does lot mean lots within the definition of lot plus parcels annexed through this annexation procedure? Which I would note was not strictly followed by Ms. Carlson. There was no document that says declaration of annexation like it says it should here, covering the applicable portion of the property to be annexed. They were attached to the Goodall deed and other deeds for other properties in the area. I mean, that much is clear. So I don't know how much of a difference that really makes. But it does, say said declaration shall incorporate declaration of CC&Rs by reference and any other additions, any additional conditions that might be desired. But you come up here, we talked about intent of Ms. Carlson, and the appellant made some cogent arguments about what that intent was. But if you go here to the actual document, it says Ethel Carlson owns additional property adjacent to Finneman Farms, etc., which was shown graphically earlier. It says this property owned by Ethel Carlson has received preliminary plat approval as Sundance Farms by the Kootenai County Commissioners. That property was never given final approval, however, by the commissioners, and those parcels remain unplatted to this day. A portion of that property receiving preliminary plat approval also received final plat approval as Finneman Farms, and as I mentioned, that plat is recorded and does still apply today. So what was Ms. Carlson's real intent? Was it just to subject neighboring unplatted parcels to the CC&Rs as she sold them? Or was she intending to apply it to another subdivision that was essentially aborted at some point for whatever reason? And since they never received final plat approval, do these CC&Rs apply? I would say no, because because her intent was to apply them to another subdivision that never happened. And that's in addition to the fact that the definition of lot itself specifically refers to Fenneman Farms that was referred to in the annexation provisions as the plat that had been given final plat approval and then was recorded. So, you know, the ambiguity is whether this definition only applies to Fenneman Farms or does it apply to the annexed properties. There was no provision in either this definition or the annexation provision stating that, you know, the definition, expressly stating that the definitions apply to the annexed properties, and particularly the definition of lot, which was narrowly defined. That's the conundrum. In fact, I think they're contradictory language, actually. This says Fenneman Farms only. Annexation says, well, CC&Rs can apply to annexed properties. Which is it? When you have a situation where parcels are where language of CC&Rs or other documents which restrict property rights are ambiguous, or in this case even contradictory. The Pine Haven case that was referenced in the hearing examiner report and in the appellant's case in chief, Pine Haven Planning Board versus Brooks, 138 Idaho 826, 829, 70 Pacific 3rd 664, 667 from 2003. The ambiguous provisions are to be construed in favor of the free use of that property. Restrictions that are not clearly expressed are not to be extended by implication. Both of these apply here. The provisions are ambiguous, if not actually contradictory. And they're not clearly expressed in the CC&Rs, as even the applicant or even the hearing examiner conceded. So because of that rule, that they should be interpreted in favor of the free use of property, that leads to the conclusion that only the parcels within Fenneman Farms are lots for purposes of the CC&Rs, and would only the provisions regarding lots in the CC&Rs would only apply to those parcels. I will say there is one thing that the appellant mentioned that I do agree with to some extent, is that these types of situations ideally should be resolved in court. That could be if, after this decision, it could be the judicial review of the board's decision in district court, or it could be a separate case brought in district court, either way. So if the board decides to reverse the director's decision, I would agree with the suggestion that it be remanded to staff to allow the court process to play out as it most likely would. But because of the ambiguity and or contradiction contained in these CC&Rs and the rule from Pine Haven that it should be construed in favor of the free use of that property to include the subject subdivision, which appellant has not raised any issue as to whether it would be able to be approved, looking strictly at our code, not looking at the CC&Rs. There has been no argument raised there. The argument is all over the CC&Rs. So my conclusion would be, and recommendation would be, that the board affirm the decision of the director. Are there any questions?
No questions. Thank you.
document.
Can you state your name, please, for the record?
Good morning, Commissioners. I'm Scott Poorman. It is my privilege to represent the Kolchitsky family in their subdivision application and in opposition to this appeal of the director's decision. I want to go back to just remind the board of what they asked for and really why. As you saw in staff's presentation, the family owns a 10-acre parcel in a neighborhood of 5 and 10-acre parcels. Nothing unusual about that particular area of the Rathdrum Prairie. As you're well aware, 5-acre minimums under health district rules for the rural zone because of on-site septic requirements. So why are they asking to split their 10 into 2 5s? And the answer is simply, they are a multi-generational family living in one house on that 10 acres. Just recently added a new grandchild to that family. And they want to stay together. That's understandable, but there's, levels of togetherness. There's together, and then there's everybody living in the same house, and that's a little too much togetherness. They have no intention of selling off one of the 5s or both of the 5s. They're doing this so they can build a second residence and keep the family together on the same property, but separately owned 5-acre parcels. And that's it. That's why they applied for this subdivision. The neighborhood itself, as you saw in the, or hopefully remember from the parcel map, I'll submit this for the record, but I've highlighted in yellow the subject property, and surrounding it in pink are all the adjacent 5-acre parcels that exist. So this subdivision application, from a land use perspective, is really, it wouldn't be controversial. It wasn't controversial. There wasn't anything about the application that would have caused it to be denied, but for this CCR question. Another thing to note is that if this subdivision is approved, it will have zero impact on the surrounding neighborhood. There's not going to be a new family moving in. There's not going to be any increase in traffic. There will be zero impact on surrounding property owners. From a land use perspective, I think the technical term for this subdivision is no-brainer. Okay? But we're not here on a land use decision, are we? We're here on a legal question. We've got 3 lawyers in the room. I feel obligated as the 3rd lawyer to give you a 3rd perspective on this, of course. One of the neighbors of the Kolchitsky family has raised this question of, are there covenants attached to this land that prohibit further subdivision? That's in the CC&Rs that were recorded by Ethel Carlson. And so it's their argument, Mr. Saul's argument, that that provision prohibits this subdivision. And it's just a pure legal argument, not because the subdivision is going to have any impact on Mr. Saul, but just because the CC&R say you can't do it, so you shouldn't be allowed to do it. The question is, the real question is, do those covenants actually apply to the Kolchitsky property? Your county attorney says no. Mr. Saul's attorney says yes. It's my opinion. I agree with Mr. Braden. They do not apply to the property, and I'll explain why. I'll try to keep this short. Never believe an attorney when they say they're going to keep it short. So you heard that the Finman Farms plat by Ethel Carlson was recorded in 1988. A couple of years later, 1990, Ethel Carlson writes this set of covenants, which you have before you on the screen. Is there a mouse I can use? Thank you. April 1990, Ethel Finman Carlson records these covenants to apply to Finman Farms, recorded in Book F, page 209. That's the only property these covenants were initially applied to in 1990. Ms. Carlson included definitions, including a definition for what she called a declaration of annexation, which would be a document recorded to attach the covenants to a particular parcel. She created a process for that to happen, and then she ignored it. There are no declarations of annexation adding these covenants to any other parcel. That is an undisputed fact. Mr. Saul's attorney will not claim there is a declaration of annexation recorded for any parcel, because there isn't. However, we're here because Ms. Carlson, as she was deeding away other parcels outside of Finman Farms, she included language in some of those deeds, and Mr. Clifton went through them for you, that appear to subject those parcels to these covenants. And the question is, was that effective or not? What did Ethel Carlson, what was she trying to do through those deeds? We can't ask her, she's deceased. We can't ask John Finneman, he's deceased. She clearly knew how to attach the covenants to other parcels. She created a way to do so through this declaration of annexation. And that's set forth in more details in paragraph or section 5 of the CC&Rs that she wrote. And she even says, I own additional property adjacent to Finman Farms. It's in the southeast quarter, section 15. That's where the subject property is located. That adjacent property, as Mr. Braden pointed out, has received preliminary plat approval. It had in 1990. And again, the Sundance Farm plat never came into existence for whatever reason, we don't know. But she goes on to say that additional lots from the above described property owned by Ethel may become subject to these declarations by the recordation of a declaration of annexation by Ethel or her successor in interest. Okay, that's the process she created. It's very specific, and she did not use it. So what is the language in the Goodall deed from which the Kolchiskis get their title? What does it mean? That these covenants are actually attached to that deed. And there's language that says subject to covenants attached and make part of. Well, I'll give you two choices. One is that means nothing, because what it comes from is it's in a warranty paragraph. This is a warranty deed. When John Finman and Ethel Carlson are deeding this parcel to the Goodall family, they're saying, we're giving you a warranty. We own this land. We promise we own this land. We have fee simple title. And that they are free from all encumbrances. This is the promise that Finman and Carlson are making to the Goodall family. We own it free and clear of all encumbrances, except current taxes. We're not making any promises about taxes. And under the same exception paragraph, subject to covenants attached and made part of. What does that mean? That's what courts are for. That's what that means. You've got three lawyers with three different opinions. And that's a question that should be answered by a court. If it really matters enough to Mr. Saul to have a court answer that question. And here's how we find out. You uphold your director's decision and allow the subdivision to be approved. If that question matters enough to Mr. Saul to put his money where his mouth is and take it to court, we'll all get an answer from a judge. And if we don't like that answer, we can appeal to the Supreme Court, and finally we'll find out what Ethel Carlson was up to when she attached these covenants to that deed. Okay, that's one answer. That's one option. The covenants are not attached because this attempt, by the very declaration itself, this attempt is not a declaration of annexation and therefore would be ineffective. That's option one. Here's option two. Because you didn't use a declaration of annexation, that process contained in the CC&Rs, then attaching the covenants to this deed must mean something else. It's something less than a declaration of annexation. And what might that be? So Ethel is deeding this property to the Goodall family, now owned by the Kolchiskis, and she's basically just saying, here's 10 acres, I'm putting covenants on it, and you can take them off again if you feel like it. Because it wasn't annexed into Finman Farms, so it doesn't become part of the Finman Farm plat, where all the other Finman Farm people have a say in whether these covenants are enforceable against this parcel or not. Finman and Carlson are adding the covenants to the title for one family, the Goodall family. And Goodall's passed it on, and then somebody else passed it on, and somebody else passed it on until it was now purchased by the Kolchiskis. And if they want to take those covenants off of their parcel, they can, because it wasn't annexed into Finman Farms. I don't know if that's the right answer or not. You don't have to decide if it's the right answer or not. What you have to decide is a land use question. And as a land use question, this subdivision's a no-brainer. It's easy. And land use is your jurisdiction. You know that. Legal questions like this, that three lawyers will come up with three different arguments for, that's the court's jurisdiction. So commissioners, drop back and punt would be my recommendation. It's my request. You don't have to decide this. As a land use matter, it's already been decided, recommended by your director, that this two-lot minor subdivision, taking a 10 and a couple of 5s, was easy and it should be approved. Let that happen. And then it's out of your hair. It'll go to court, or maybe not. Because frankly, why does it matter? It's not going to affect anybody's property value. It's not going to impact anybody's enjoyment of their land. This area is surrounded by 5-acre parcels. It'll increase your tax base. You'll have another taxable parcel with another house on it. There's a plus. So, and I'm not trying to be flippant about this. Realistically, you don't have to decide this. Well, there's an appeal before you that you have to decide. But look at it as a land use question. And as a land use question, it's easy. As a legal question, let the court decide. That's where it belongs. I'll just leave you with this thought. Ethel Carlson wrote her own covenants. She knew what they said. And she didn't follow that process. If she had, we wouldn't be here. It'd be easy. So you're left with two options. Either she was intending to do something different from an annexation, or she just forgot. It didn't matter enough to her to do it right. And if that's the case, either way, these covenants don't apply, or if they do, they can be removed by the Kolchiski family all by themselves. If you want to make that a condition of approval, that's another way you could take care of this. You could say, we'll approve your two-lot subdivision, but first you have to record something removing these covenants from your land. Or even just remove the no further subdivision restriction. And then you're in the clear. Thank you, Commissioners. That's all I have. If you have any questions, I'm happy to answer.
Thank you. No questions. Thank you.
Read into the record as B 1002 exhibit.
This one?
What was your point?
So next will be anybody that wants to testify in favor of the applicant / respondent.
Do we have anyone here or on the phone who would like to testify in favor of the applicant or respondent? Jonathan?
Suzette, did you wish to speak to this issue? If you do, unmute yourself and go right ahead.
Looks like she is unmuted, actually.
Well, that says, oh yeah, she is unmuted. Suzette, did you wish to speak? Apparently not.
So
Okay.
next would be rebuttal.
Okay, so the appellate has a rebuttal. And how much time do we have? 15 or 10 minutes?
I'd be liberal with that.
So 15 minutes.
I'll try to be succinct as possible. If we could get the exhibits back up. A couple items to address. I want to talk about the declaration of annexation. I want to talk about Mr. Portman's unilateral amendment. But I also kind of want to just start here, talk about this judicial review that's been tossed around, right? I think there is an important policy should be applied here, that this is the applicant's burden to show that the CCRs do not apply. It should not be the action of the county to force the appellant, who is simply trying to uphold a property right, which a CCR is, to have to go and sue the applicant for this process to occur. It should be the burden of the applicant. They're the one applying for the subdivision. They're the one that needs to show that it comports with the CCNRs. If it's a legal decision that it needs to be made, it should be their burden to bring that case and require that to occur, not really an independent third party. And secondly, we talk about no impact to the area. Well, we're setting a precedence here if we approve this subdivision, right? That means that everyone else, the other 10 lots we talked about, which are all 10 acres, will have the right, potentially, to approve a subdivision. What happens to the private road that's now being used by all those individuals, right? And the changing the complete structure of that neighborhood if you have 10 more lots in that area. So I think it's short-sighted to say that it has no impact while we're looking solely at this particular action when you don't look at the potential actions as a result. Now, let's talk about the declaration of annexation, right? Because both the county and the applicant have made the argument that, there was no document entitled Declaration of Annexation. So I want to just take a look at what is the definition of a declaration of annexation. Okay, we're talking a lot about definitions today. So this shall mean and refer to a recorded instrument by the terms of which a particular parcel or parcels of property may subject that term to of this declaration. So it's a defined term of a recorded instrument. Now, we've had a lot of case law thrown around. I'm going to throw out one more. Okay, there's a case, C&G Inc. v. Rule, which makes it clear that the title of a document is not determinative as to its effect. In C&G Inc., it was a right-of-way deed. It's part of a railroad scenario, which are commonly litigated, and it found that that was not an easement. That was a conveyance and fee despite the fact that it was a right-of-way deed. So here, not having a document entitled Declaration of Annexation is not determinative on the issue. I mean, let's look at the annexation process. Okay, so here we are. It's, like I said, it's simply a defined term. Paragraph 5A requires the following for a property to be annexed, okay? It has to be owned by Ethel at the time the CCNRs were recorded for Fenneman Farms. There's no dispute that that's the case. The property must be located in the southwest quarter or southeast quarter, section 15. No dispute that that's occurred. It must be recorded by Ethel Carson or her successor in interest. It must describe the particular portion of the property to be annexed, and it must incorporate the CCNRs. The good old deed I provided to you meets all of those criteria. And I would push back on Mr. Portman's position that I would not say there's not a declaration of annexation here. I would say there's several declarations of annexations that have occurred. The title doesn't matter. Now, the unilateral amendment argument ignores the variance or amendment provision that was not discussed. Okay? Now, the county, despite, again, Mr. Portman's representation that the county and he agree that they're not attached, they actually agree that it is attached. Their position is that these have attached to the property. So the variance requires a 2/3 vote of the owners of the lots subject to this declaration. That means 12 of the 17 parcels subject to these declarations have to choose to approve an amendment allowing segregation or a variance for this particular parcel to occur. So it's not a unilateral move that can be made. And then it's kind of a new argument regarding the Sundance Farms. I would argue that this is just a further description of the property, right? I don't think it's determinative on the effect of the recording or a declaration of annexation. And so I just go back to the fact that you're essentially, if you approve this as applied or as approved by the director, you're asking my client to have to go to court to prove that the CCNRs exist, in which it should be the burden of the applicant party to show that they can meet the requirements to allow it to occur. And that's a really straightforward and reasonable and understandable position. And it should be the position of the board should they choose for additional review. They should either subject it back to the director on a determination that the appellant must undertake to determine that they meet or that these CCNRs do not meet or are not subject to the property. It should not be the other way around. And so I want to just address one final thing the hearing examiner stated. He stated, and this is in the documents we're asking to approve, I would expect that a court of proper jurisdiction would uphold the applicability of the CCNRs to this parcel. Upon review, I do not conclude that there is vagueness rising to the level of inapplicability. Focusing on one defined term and the CCNRs is missing the forest for the trees. Given a comprehensive review of this parcel's history and that of the other adjacent parcels subject to the CCNRs, it seems clear to me that the intent of the original grantor of the 1993 deed meant to make all these parcels subject to the terms thereof. So I think it's clear too. I think the information we've provided you today is clear, and I would ask again that you do what you did in the previous appeal and deny. Or I guess I would say approve our appeal and deny approval of the short plat. Any further questions? Thank you. Appreciate it.
No, thank you very much. And at this point, do we take any additional comments from people or?
No, I think at this point it would be appropriate to make a motion to close the appeal hearing and enter into deliberations at such time as the board sees fit.
Oh, I'll take a motion.
Yes, I make a motion that we close the appeal hearing.
And I will second that motion.
Bill Brooks.
Aye.
Commissioner Matari.
Aye. And now we enter into deliberations or,
You
Or
can
set
do
a
it.
time.
You can
Set
do
a
it now or
time.
schedule it for another time.
yeah, I would like to schedule that for another time.
Okay. Make a motion and
So I move that we schedule the deliberations for APP 22-0003, the appeal of MIN 21-0043 for the next community development meeting on June 15th.
I second the motion.
Yeah, June 15th. And Commissioner Brooks seconded the motion.
I'll do it again if you want.
That's at 9 a.m.
Bill Brooks,
Aye.
Commissioner Matari.
Aye. Motion carries. So thank you very much. And now we move on to item D. We'll go with the first item in that, which is MSF 22-0004, the club at Rock Creek, 4th edition.
Thank you, Commissioners. Vlad will be handling this case.
Okay.
Vlad, can you do a screen share?
I can drive one. Sure. I got this.
Are you on Zoom?
Yeah, I just got you.
That worked, thank you.
Yep.
Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development. I'll try to be as brief as possible. As you may know, a review of the major subdivision final plat application is not to approve the proposed density, but it's merely to confirm that the conditions of approval set forth in the preliminary decision have been satisfactorily met by the applicant based on the comments from the agencies with jurisdiction. This is one of the phases that the applicant is seeking to get approval on. And when you receive the recommendation from staff, excuse me, in the course of proceedings, I'd like to clarify that there were a number of decisions that predate the current request. The original application of the planned unit development, it started out with Black Rock PUD, and then it was converted to Rock Creek. The club at Rock Creek was originally approved back in 2005. We have since received a request from the previous owners, and now the current owners are pursuing that as well, to amend the original PUD, which was approved in 2016, as well as a preliminary major subdivision concurrently with that PUD amendment. And the subdivision was approved, MSP 16-0004 was approved in August of 2007. That subdivision is in line and consistent with, or congruent with, the overall density that was approved in the amended PUD plan. The amended PUD plan comprises of 935 acres with a total of 417 units. The PUD cumulative chart of densities had a very comprehensive set of ranges within various areas of the PUD plan. I don't understand the complexity of it, but the ranges basically say you can develop in various areas of this plat, and you have the range to deviate from a very small density to a very dense density within certain areas of this project. The reason I bring this up is that as part of this application, the applicant is developing this area of the planned unit development with this phase, and they're seeking the approval of 40 individual residential lots, as well as one multifamily lot, which will consist of 5 buildings and 5 units in each building. As a result of this final plat approval, there will be a total of 65 units platted on 41 lots. Additionally, they're requesting to plat 11 tracts, and the uses of those tracts will consist of roads, private roads, utility tracts, as well as open space tracts, which was all contemplated as part of the PUD approval in the 2016 amended order of decision. These are the two tracts in question, or the two parcels in question. This one will be developed. This will be an open space. It will be a continuation of the golf course. It's just being platted to formalize the use of the site as part of the PUD overall recreational area. This is the proposed design of the subdivision. It will consist, like I stated, of 40 individually created residential lots, as well as this multifamily lot which will have 5 units on it, and 5 buildings with 25 units, 5 units in each building. Access to this phase of the plat will be off of Lost Bay Road via an internal private road, National Drive. Water will still be provided by BlackRock Utilities, BRU, water and sewer as well. As I stated, the applicant is requesting a deviation from the original density range. They're asking to have a lesser density within this area of the PUD, which we determined will have a lesser impact, if you will, and they could exercise that density that they're not doing in this phase elsewhere within the PUD. So I think I don't want to use that word, but maybe Mr. Braden can correct me. It's almost like a transfer of development rights from one area of the PUD to another area of the PUD to deviate from the approved density range, if that makes sense. I don't know if that's the correct way to explain it, Mr. Braden.
I think that's valid.
Distribution, density distribution.
Yeah.
Yes, and we find that to be a non-issue on our end, but the board definitely could ask questions in that regard. The other point I'd like to make is that this application has been on the books for quite some time. The reason being, the uniqueness of this request is that while we did receive a letter, a will serve letter from BRU, BlackRock Utilities, that they have the willingness and the capacity to serve this phase of this plat, we have received a subsequent response from Idaho Department of Environmental Quality that stated that while they are not opposed, or they believe that the district has the ability to provide services, the facilities master plan has not been updated to I don't know if the right word would be to support, but it has not been updated to be in line with the state standards, if you will. And this has gone back and forth. I believe the applicant at this time is working diligently with DQ and BRU to help them address the update to the facilities master plan, and it's in the works. One of the issues that we did have is the code clearly states that any lots that are being platted must be of reasonable utility and livability, implying that it could have water and sewer facilities provided. The applicant has gone back to BRU as well as DQ, and the compromise that's been made, which has been reviewed by our department, Mr. Braden, our legal counsel, as well as DQ, is to allow for a conditional lifting of sanitary restrictions that DQ, BRU, as well as Panhandle Health District are amenable to, which means that they will lift sanitary restrictions to record the plat. However, prior to seeking any building permits, the applicant will have to demonstrate that the facilities master plan has been accepted and approved by DEQ to be part of the BlackRock Utilities master plan, if that makes sense. And I believe that may take some time. I think that master plan is currently being reviewed by DEQ, but it may take a few months in order for that to be finalized. But because our department, on the advice of our legal counsel, as well as DEQ and Panhandle Health District are on board, we feel that the recordation of this plat would not be in conflict with the provisions of our code that state you can only plat lots that are reasonable utility to livability. This will be done shortly. It's merely a legal formality to have that master plan be approved. I stand for any questions that you have for me at this time.
Do you have any questions? I'm just curious, I understand the concept here about not wanting to put the cart before the horse, if you will. What are the possibilities where something could go wrong, where we could end up kind of saying yes to something a little bit out of sequence, and later going, okay, we just got ourselves into a little bit of a corner on that? What's the likelihood that this facilities master plan could run into issues because it needs to be addressing I'm assuming the size of this development to be able to service it?
Commissioner Matari, it would probably sound cliche if I were to say, to be honest with you, I'm being honest with you. I have asked that question myself. I don't have an answer for you.
Okay.
I'll take a crack at it too. I think well, first of all, I think the applicant has a very strong incentive to do right by DEQ in terms of making sure that that master plan is updated to DEQ satisfaction. They stand to lose a lot of money, frankly, if they don't. So, nothing's ever guaranteed, but I'm pretty confident that that will get done. And we do, have a gatekeeping function there in terms of, they won't be able to get development permits until that is taken care of.
And is this just a capacity issue with the facilities, or is this just basically a document that has to be updated?
Commissioner Matari, I do not believe it's a capacity issue. And as I stated earlier, I believe, from my understanding, is that the facilities master plan, the document itself, has to be congruent with the capacity that BRU has in terms of water right and other application in terms of their sewer plant that, has all the effluent conveyed to it. I think that the document that the state has to approve, the state agency has to approve, has to accurately demonstrate how it's physically being done at the facility. If that is
So
that
I have a quick question of Vlad, if I might, to follow up.
Absolutely.
So you're saying that PRU already has the capability to provide water and sewage treatment service to this development? It's just that the document has to be updated to reflect that, or are they adding capacity to it?
No, I don't believe so. I think the first analogy that you made is correct.
They already have the capacity.
If I can, I'd like to double check. Can I go on Zoom and double check the exhibit that we have on record for this file? Is that okay? Is that appropriate? I'd like to bring that up on the
Yes,
screen.
if it's already in the record, that's fine.
Okay.
It's fine.
Whatever you want to do, I'm fine.
Yep. While you're getting there. David, can you see that?
It's not on my screen. Now it is.
So commissioners, we have this letter from BlackRock Utilities dated November 3rd of 2022 that states that
Willingness and capacity to provide water.
correct, yes.
Yeah.
So, maybe Mr. Braden can clarify, I think the facilities master plan it's just a formal way for the state to recognize that their plan is consistent with their ability to provide services that is in the works at this time.
So back to your original concern, I think there's little chance that you could approve something that'll be problematic.
I would agree, given this letter.
Okay. That's it for my questions. You want to make a motion?
No, why don't you make it?
Okay.
That would help.
I move that we approve MSF 22-0004, the Club at Rock Creek, 4th edition.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye. Okay, the next item is MSP 22-0004, Lakestone continuation of deliberations. Yes.
Commissioners, I'll lead off if that's okay.
Absolutely.
Staff talked with Lakes District staff yesterday, and we received confirmation that they are still of an opinion that they will not allow a gate as part of the approval of this subdivision. So that brings us back to, in my view, you have 4 possible outcomes. You could approve without the gate, you could deny, and you just need to state reasons why you believe denial is warranted. Off the top of my head, I think an easy start would be traffic concerns. Or you could approve with the gate, with the logic that that's effectively a denial because Lakes isn't going to allow it and they will sign the plat. A 4th option we haven't discussed, but I think is viable, is that you could consider reopening the public hearing for new testimony. And I can't really say what the new testimony would be in detail at this time because it hasn't gone to Lakes, and I don't know that the applicant is comfortable with me revealing that publicly. But I know there's some options that haven't been discussed in your original public hearing, or at least one option. And it's conceivable that that one option might be somewhat agreeable to the neighborhood and the developer and to Lakes. So those are your four options that I know of. In your shoes, I'd be inclined to talk with my legal counsel in executive session because 3 of those 4 options I just mentioned to you are likely to end in a lawsuit.
Okay. Do you have any questions or thoughts?
No, I think that's a good idea that we get together with Pat in an executive session and discuss these things.
Would we do that now, or?
Can do it now, or you could schedule it for a later time, either one.
I think Leslie would like to be involved.
I think,
in
yeah,
this,
we should schedule that.
I would agree with that.
So, so you want to make the motion, or?
Yeah, I move that we schedule an executive session with our legal counsel at a time in the future when Leslie can be present.
And I'm going to second the motion, but I just want to clarify, we can discuss any one of the 4 options that
Yes.
Director Callahan. Okay, I second the motion.
Bill Brooks.
Aye.
Commissioner Matari.
Aye. Okay, so the motion carries. At this point, I'll open it up to public comment, or is that just for any of the particular issues here that we had today?
Deliberations aren't
Well,
typically.
you can,
No.
yeah, I mean, you can open it up to public
No.
comment. That's your,
I will go ahead and just say that it's 11:37 and the meeting is adjourned. Thank you. Item F.
And
Thank you,
Goodbye.
commissioners.
Set strict time limits, please.
Yeah, well, you have 3 minutes.
Oh, that's fine, that's fine. Thank you very much. My name is Tanya Osterson, and I live at 1919 North 9th Street in Coeur d'Alene. Please add my statement to the public record. Back in March, I sent you a flyer for the rights of citizens in the deployment of wireless infrastructure. And I think Jonathan put it on each of your desks. Anyway, I hope you had a chance to watch this webinar. One of the keynote speakers was Andrew Capinelli, attorney. He has assisted many local governments in the drafting of zoning ordinance governing the installation of cell towers. He has an extensive bio and in fact was hired by the city of Dalton Gardens to write their wireless telecommunications ordinance. It was signed into law last summer. This model ordinance was vetted for Idaho by attorney Norm Semenko, who is representing the Potlatch Hill residents. We are handing you a copy of the ordinance that you can use for Kootenai County. This has a lot of value in terms of time, energy, and money, and should not be taken lightly. This ordinance asserts all the rights reserved to our local communities by the FCC and case law. It does not prohibit anything. It is detailed and comprehensive. By careful choice, you can tailor it to Kootenai County. Your current ordinance allows for a cell tower as close as 300 feet from a residence when it needs to be at least 1,500 feet. Who is responsible for the excessive emissions these cell towers are spewing out? They are causing harm to our biology. Who authorized those apartments to be built around that cell tower near Prairie Avenue and Ramsey? We had an incident on the evening of April 7th where several of us experienced radiation poisoning, headaches, and tingling sensations in our bodies because the power from the antenna array on top of the 10-story apartment building across the street from the cafe was excessive. I had tested it with my meter before and it has always been extremely high. There are other cell towers nearby. You can stand right outside this admin building and see these 2 wireless facilities. The average power density in microwatts per square meter goes as high as 50,000. We took this incident to Sean Holm in the City Planning Department, and he gave us the FCC number to call. Did you know that the FCC is a captured agency? Their commissioners are former wireless industry insiders. This should be a local issue specified in a protective wireless ordinance. You take an oath to protect and serve the people of this county. Let us take back our power at the local level. Your hands are not tied. The law is on your side. Thank you.
Thank you. Does anyone else have any other comments they'd like to add? Okay, you can come up to the podium. You have 3 minutes, and please state your name for the record.
Thank you. My name is Rhonda Sand. I live at 14325 South Highway 3 in Rose Lake. I own 3 additional properties in Kootenai County. I've had a company here for 25 years. My father was a retired fireman. I'm very well committed to this community. I have grandchildren here. First, I want to commend you all for your position with the Potlatch Hill cell tower. But most of the problems that we're facing now could have been avoided if Kootenai County would adopt a current and protective telecommunications policy. And just while I was sitting here in this meeting today, quite interesting that we had 3 attorneys here, and we spent a good amount of time on one piece of property that represented one family. And I bet we looked at probably 100 pages of documentation. But what you need to face is the fact that you only have a 2.5-page policy that goes to protect the entire county right now that needs addressed. We've just spent 45 minutes with 3 attorneys in the room for one piece of property. And Bruce just said moments ago regarding this project at Club at Rock Creek, he said, what are the possibilities of something going wrong and we were to run into issues that need addressing later? That's what you said regarding this club at Black Rock, which is 60 residences, 900 acres. You are facing a freight train with what is happening with the telecommunications industry. The telecommunications industry is a $1 trillion industry. The amount of attorneys that they have behind this industry is insurmountable. But you have the ability in your hands, these 3 people on this council, to set up a policy, a written policy. Right now, the policy that you have is completely inadequate. It is so inadequate that now you're going to face a lot of trials coming against AT&T. It's completely unnecessary. With Andrew Campanelli, this very famous telecommunications attorney, Dalton, just down the road, already went through all of this. They've invested hours, hundreds, of dollars, thousands of dollars in creating this policy. All you guys have to do is tweak this, hire Norm Sabanco, and get it geared towards Kootenai County, and a lot of our county problems will be resolved as far as telecommunications, because if things begin to unwind, with the telecommunications industry and the Wi-Fi cell towers that she's talking about, that these people that have EMF issues, you can't taste it, you can't smell it, you can't hear it. You're not aware of it. But what will begin happening is massive issues, not only with human health, but I'm talking about all life, our soil life, our water life, our animal life, our plant life. These are the things that you're going to be responsible for. So I would urge you, please, do the easy route. Take a look at what Dalton just invested in a year ago and just tweak it. And let's protect ourselves immediately, because there's a freight train that's coming down. Okay?
Thank you very much. Was there anybody else?
Read into the record as Exhibit B 1003.
No, at this point, I'm going to go ahead and close public comment. And at this point, it is 11:45 a.m., and I'm going to adjourn the meeting. Thank you. Thank you, everyone.